Thank you, everyone, for your patience. I'm calling the matter of Arfin Hack versus Barbara Hart. This is our case number 25-62206. Today's the time set for a second hearing on the landlord-tenant matter. Counsel, can I get your appearance, please?
Certainly. Good morning, Your Honor. Alan Dyer, appearing on behalf of the plaintiff, P54857.
Ms. Hart, can you state your name, please?
Barbara Hart.
I should note I've received documentation from Ms. Hart. I don't know if it's been provided to the plaintiff. I also have a set of pictures. I don't know if that's been provided to the plaintiff. If I could just get a quick summary from counsel as to what you're looking for moving forward, and then I'll give Ms. Hart the opportunity. And I'm going to go from there in determining whether I need to take any testimony or what needs to be done. Go ahead, counsel.
Understood. Thank you very much, Your Honor. This is a hearing on our complaint for non-payment of rent. It's our position that there is arrearage owed, $1,900 in arrearage, which includes a partial payment for August and the entire month of September. There are 6 late fees at $200 each, totaling $1,200. Accordingly, Judge, we show the arrearage at $3,100. There are court costs today of $266.93, which includes a $150 statutory attorney fee for a contested hearing, for a grand total of $366.93. I did, in fact, receive a multitude of emails yesterday from the defendant. I was stuck in bankruptcy court for a significant period of time yesterday afternoon, and then I was in court again this morning. So I haven't really had an opportunity to digest them, other than to say that there was a lot of them. Judge, my client has a certificate of compliance on this property. Initially, the date of approval was 9/29/2022. It expired on April 13, 2025. Thereafter, my client had the property re-inspected. Some minor issues needed to be addressed. My client diligently addressed them to the best of his ability, based upon the fact that the contractors had a hard time getting access to the property. Ultimately, Judge, the city did inspect the work and approved the work again, and said that the property is fit and habitable for tenancy, and the date of approval of the second certificate of compliance that I referenced is September 2nd, expiring in 2028. It's our position, Judge, that there are no issues in any of those voluminous emails or pictures that go to habitability issues. I do understand that at the inception of this lease, which was back in February, that a credit was given to the tenant for some cleaning and for some lack of ability to utilize the garage for a period of time. I do understand that my client is here, as well as his contractor, who are prepared to testify to these facts, but this is the overview from plaintiff's perspective.
I appreciate that. And before Ms. Hart, you proceed, let me note that based on what I often see in cases involving allegations regarding habitability is that many of the issues raised by tenants seem to go to cosmetic issues. If what Ms. Hart is alleging is true, however, I think there are significant issues in this particular case. That's going to require, if we can't otherwise resolve this, that's going to require testimony, and it's going to take a little bit of time to sort through. Before we get there, Ms. Hart, you don't need to go right now into all your allegations. My question is, what are you looking to do? I'm assuming you're not wanting to stay in the property. But maybe my assumption's incorrect. Will you tell me what you're looking to do?
I want the landlord to fix it up to where what they added in the contract in the first place that was signed for us to be able to use. There's stuff in the contract that is not true, that we never got to utilize, like the garage. It was maybe almost 2 months, and they started working on it right before the inspection had to be done.
All right, we're getting into the weeds of it now.
Okay, you're right.
I'm asking you a question. You want to stay in the property?
I'm going to stay there, but I want the landlord to give us use to what we're supposed to have and what's in the contract. And if he can't do that, to take money off of the rent that we don't get use of, and that the reason we were late quite a few times, I threatened to not give him rent unless he started fixing stuff up that was supposed to be fixed.
Did you escrow the rent money?
Pardon me?
Did you escrow the rent money? Did you put the rent money aside?
No, the first month he did for $200 off for not having use of the garage.
Did the money that you did not pay in rent, did you have that set aside and available to pay the landlord in case I rule that he's entitled to the money? Do you have the money if I rule that way?
Yes, but I feel I only owe 19 because I don't think I should have to pay the late fees, and I think he should take money off for every month that has been rented for not offering what is in the contract.
Okay. All right. I think I got your position. Here's my position. I'm going to have to obviously hear testimony. I'm going to have to look at documents. I'm going to have to look at pictures. So I'm going to need everybody here in person to do that. I can try to accommodate you in that regard. I would like to suggest, however, it seems to me that this relationship is broken despite there being a contract. It seems to me like a negotiation should be entered into to give some significant relief from the allegation of the amount of money owed by Ms. Hart, but also with the look down the road of Ms. Hart coming to terms with this relationship is not going to work out. You got a lease going through the end of 27. This is going to be a constant struggle and a constant problem. So I'm going to suggest you talk about a move-out date and, from the plaintiff's perspective, a significant waiver of money you believe you're entitled to. What do we got this afternoon? Nothing. I could actually go to trial this afternoon if you all want to come in at 1:30.
Judge, I have to apologize. I am not available this afternoon.
No, I understand. I've been doing this long enough. You're a busy man, I'm sure.
Yes.
So I can try and work out another date. Not that this is your problem, but we're a 2-judge courthouse and we have one courtroom unavailable because of structural problems. So we're trying to fit 2 dockets into one courtroom. If I can't do it this afternoon, I'm not sure when I'm going to squeeze you in and do a trial. I think what I'd like you to do, counsel, if you got some time this morning, talk to your client, break out, think about what I've said and how you may be willing to resolve this. I suspect he'd rather have Ms. Hart out, but I'm going to encourage you to give her a real fair amount of time to get out and walk away from some of the money. Ms. Hart, from your perspective, I understand you got a contract and you want to hold into it. And let me suggest to you that living in this property for over another year, it's not going to be pleasant. I want you to think about your options and moving out and what might satisfy you in terms of when you can get out and what kind of relief from the money you would otherwise owe that you'd accept. And then I would like you to talk. And if you can't resolve it, fine. Then we'll come back in and we'll pick a date to do a trial.
Understood, Judge. And what I might suggest here, just as food for thought for the tenant, is, sometimes in these cases, what we do is try to convert them from non-payment to termination, where we don't even talk about money. We just simply part company gracefully. That's something that we can have a conversation about before the next court date after today.
Counsel, you've been doing this. That's exactly what I'm suggesting.
Right.
All right, Ms. Hart, think about that a little bit.
Can I speak one more time?
Yeah, go ahead.
First of all, if you want to do a trial and stuff, because I would like that, I would get a lawyer too, because I really didn't think I needed one, but I will. And he has $2,400 of my money that was paid to him as a deposit.
Okay. Well, one thing I could do, and I don't want to belabor this too long, but I know the next good court date I could give you, as a pre-trial, is not till October 9th. If you just want a pre-trial date and you think about your options and you work it and you come back on the 9th and we pick a trial date, we could do that. If you want to stick around and talk, I'm here. I'm not going anywhere.
Judge, what I might suggest here is that we roll with that pretrial date, but I would ask that the court establish escrow going forward. The rental rate is $1,600 a month. We would ask that an escrow order be ordered, and that we, at the pretrial, obviously we'll try to talk before then if we can resolve it either directly between myself and Ms. Hart or between myself and any counsel Ms. Hart retains. I'm more than willing to have the conversation, but I would ask for an escrow order to sort of preserve the status quo.
Payments due at the first of the month?
Yes, sir. Yes.
All right. So, Ms. Hart, what the attorney's suggesting, and he's absolutely entitled to this under the court rule, there's a specific court rule where if a judge pushes a matter off, that there's an escrow required to be paid. So, moving forward, I'm going to require that $1,600 a month. You pay the court. You don't pay the landlord, you pay us. Come into the court October 1st, pay the $1,600. We'll hold the money. And when we eventually get around to having a trial or settling the case, I'll make a determination as to who gets that money. Do you follow?
Yes.
Okay. So what I'm going to do today is I'm going to send you both a notice that we'll have a pre-trial. It's a pre-trial. It's not a trial. So we can do it by Zoom, October 9th. At 10, Kim, let's do 10:30.
Yes.
At 10:30, and there will also be an escrow order as part of what I'm sending you that you need to pay $1,600 a month on the first of the month. If the case goes long, I don't want it to go long, but every month thereafter, pay to the court. All right?
That's fine, Judge. And one final word. Ms. Hart, if you wish to reach out to me or have your counsel reach out to me directly after this, we can try to start the conversation about resolution.
Okay, thank you.
All right, thanks, everybody. You'll get an order. It'll go out in the mail, and it'll be in the electronic system today.
Thanks so much. Have a great day, all.
And I'm holding on to your documents, Ms. Hart.
Thank you.
In the future, if you send anything to the court, send it to the other side, too, so they have a copy, okay?
Okay.
All right. Thank you.
Thank you all.
That's it.
So we might need